What does this mean? That DHS is ending automatic EAD extensions. And for people watching, how was it working before this change?
So, maybe the better starting point is to go all the way back to 2018 when the real problems with the first Trump administration kicked in. And that's when we saw them create this bogus requirement for everybody who's getting an H-4 visa extension to get new biometrics. And it applied to the L2s, the E2s as well. That was something we litigated pretty heavily. And it turns out in the government records that all of their explanations for why this biometric requirement was necessary were bogus, and we caught them in that in court. So they got rid of the biometric requirement, but they were refusing to concurrently process the primary H1 or L1 with the derivative spouse, their applications for extension and EADs. And the decoupling of those things, which had always been done together, decoupling caused massive delays. So instead of one adjudicator looking at 3 petitions that are all the same information, now we have 3 different adjudicators shuffling papers back and forth in a kind of a messy, complicated process that ended up, delaying things substantially. What that meant was the earliest you could file your EAD application and your extension of status is 6 months prior to its expiration. So when USCIS is taking 9-10 months, you're out of job at the end of the 6 months, and you have a period of unemployment. And it became very difficult for H4s, L2s to maintain employment, because employers were scared that if they have this person, they're going to lose their employment authorization, and there was no predictability as to when they could be back. So, that was the next issue we just And as the result of all of that litigation, a couple of things. One, biometrics were suspended for the status extension, and they recombined the primary, the derivative applications. The other thing that we were able to do, just because of a difference in the statute between L2s and H4s, is we were able to get the agency to concede that L2s don't have to file an EAD application. They have employment authorization, what's called incident to status. And that was something that had been, to me seemed very clear and apparent in the law, but the agency had just never acted on, and nobody had ever pushed that issue before. So we litigated that, and we got L2s, their employment authorization incident to status. We got them to combine back the adjudications, and also made H4s eligible through that litigation for auto extension. We're tired of getting sued by us, because I think we had more than 2,000 clients that went through this process and got their EAD cards through the mandamus process. And so they're tired of getting sued. So then they went through the rule change and the regulatory process of allowing auto extension on renewal applications for EADs that last for up to 540 days. And that was kind of an acknowledgement on USCIS's part that they are a bumbling organization that is horribly inefficient. And they wanted to give themselves a ridiculous amount of buffer space so that, at the end of that EAD, they're not getting sued, and they have ample time to do any RFEs, any, further development verification that they need to before, adjudicating the EAD. That's the background. That's where we came at. And all of the settlement negotiations and settlement agreements we had expired on January 20th of this year. And that's when you see the Trump administration do its first move against the H4 EAD especially, which is they said they are no longer obligated to concurrently process. Now, a lot of people are still getting concurrently processed, which is great, but legally they're not required to do that any longer. What we see now is by getting rid of the auto extension, it's pretty clear what they're trying to do, especially the H4s. Now, the H4s under the Trump administration were targeted pretty heavily. And they were going to try and get rid of the H4 EAD through the regulatory process, but they could never get it right. The Office of Management and Budget within the White House kept returning the proposed rule back to USCIS because it kept screwing up the rulemaking process. So what they couldn't do legally through a rule change, they're trying to do by creating hurdles or obstacles in the adjudication process. And they're trying to kill the program by a death by 1,000 paper cuts, by slowing down the adjudications so that you lapse on your employment authorization and you have to leave the workforce.